Hey guys, welcome to today's Legal 101. It is the last one of the week and it's on constitutional and human rights law. It comes after what I heard on the news as an avid listener of the radio. The governor of Mombasa, Abdul Somad, was talking about the increase in crime rate in Mombasa. He was saying that now that the schools are closed, children between 14 and 16 years of age are taking up knives, scaring people on the street, stealing from them, jeopardizing tourism in Mombasa, jeopardizing business ownership in Mombasa. And he was saying that they are being arrested, and he was calling upon the courts to reduce the manner in which they issue bail willy-nilly. And in fact, he was saying he wishes to arrest their parents, their guardians, because they are not aware of where the children are. That during school days, none of these things happen because the children are in school. So he was saying he would wish that these parents and guardians are arrested. Now, of course, that is not something that is provided for under the law. A person who commits a crime is liable personally. You cannot arrest a parent for the crimes of a child unless you actually have proof of an offense conducted or made by the parent. So I looked at the provisions of the Children's Act, the Penal Code, the Constitution, all of that, to give you an appraisal on this whole issue. And number one, a child in conflict with the law is a person who is above the age of 12 but below 18, who has dealt in some way or has been punished in some way under any written law or under the Children's Act for commission of an offense. Now, Article 53 of the Constitution provides that every child has a right not to be detained except as a measure of last resort, and when detained, to be held for the shortest appropriate time possible and to be separated from adults and in conditions that take into account the child's sex and age. To proceed, the Act further provides, the Children's Act further provides that people under the age of 12 are not criminally responsible for any acts or omission. But between 12 and 14, they could be if it is proven to the court that they actually understand what they are doing. Typically, the court will not consider them as people who actually understand right from wrong, but if there is evidence, then the court will indicate that they are criminally responsible for their acts or omissions. Now, so you might want to ask how the courts deal with children in conflict with the law. Number one, they discharge the children under Section 35 of the Penal Code. This is where there is no need to assign them a probation officer. They are let go and told that if they commit another crime, within 12 months of their release, they will be brought back and sentenced for this particular offense and also charged with a new offense. Number two, they can be discharged after they have entered into an understanding with the court to show up in court on certain days for routine mentions, whether or not they have sureties in place. Number three, a court can make a probation order under the of Offenders Act. Number four, they can be committed to the care of a fit person, whether a relative or not, or a charitable children's institution willing to take care of them. If the child is between 12 and 15, they can be sent to a rehabilitation institution. If they have attained the age of 16, they will be dealt with as provided under the Boston Institutions Act. You can Google Boston Institutions just on Google to see what that is about. And they can also be placed under the care of a qualified counselor or psychologist. They can be placed in an educational institution or vocational training program or a probation hostel under the provisions of the Probation of Offenders Act. The court can make an order for community service, can make an order for supervision, can make an order for restorative justice where the offender sits down with the victim in a bid to perhaps express their remorse, to express their willingness to be different, and perhaps that is just enough for the victim. The court can also make any other orders for diversion. All the things we have mentioned are actually orders for diversion. Basically, it means providing programs or intervention designed to divert the children from entering into a life of crime. But of course, more can be done with the aim of reducing stigmatization, identifying children who are likely to involve themselves in criminal offenses, providing programs for them to keep them busy, and just programs to reduce recidivism, which is the recurrent commission of crime by one person. And lastly, which already is provided under the law, which is what the governor was proposing, is that the parents or the guardians are held accountable. And this is one of the ways in which they are held accountable already as provided under the law. The child may be ordered to pay a fine, compensation, or costs, or all of the above, having regard to the means of the child's parents or guardians. Yeah. So while they cannot be arrested for the crimes, for the acts and omissions of their children, they can be punished under this provision of the law, where the court makes an order for payment of a fine and it is paid by the child's parent or guardian. So that marks the end of today's Legal 101. See you next week. Send this to the governor. Tell him to get his county attorneys to advise him accordingly. That said, I have not run a county, so I do not actually know how much of an inconvenience it is to run that county. I do know they are doing some things very well. I think I heard it from our senator in Nairobi, Sifuna, where he was saying that their equivalent of Dishina County is actually working very well. So they are actually providing for children. They have the best interest of a child in mind, but I think it should also cover children in conflict with the law. Okay, that is the end. Bye.